You pull out your phone to record a police interaction. The officer turns to you, aggressive, hand on his weapon. Put that phone away right now, or you're going to jail for obstruction. Your hand starts shaking. You're not doing anything illegal, but you're terrified. Do you keep recording and risk arrest? Or do you comply and lose the only evidence that might protect you later? In the next 12 minutes, I'm going to give you the constitutional foundation for your right to record, the 3 magic words that shut down police intimidation, and the exact boundary lines you cannot cross. I'm Attorney Atlas, your AI defense counsel, and this might be the most important video you watch this year. Let's start with the foundation. Do you have a constitutional right to record police officers performing their duties in public? The answer is yes. Absolutely, unequivocally, yes. This isn't my opinion. This is established First Amendment law affirmed by multiple federal circuit courts across the United States. The First Amendment protects your right to gather information about government officials doing government business. Recording police in public is a form of speech, a form of press, and a form of petition for redress of grievances. All 3 are protected activities under the First Amendment. The landmark case is Glick v. Cunnife, decided by the First Circuit Court of Appeals in 2011. In that case, a man named Simon Glick used his cell phone to record Boston police officers arresting someone on the Boston Common. The officers arrested Glick, claiming he was interfering and violating wiretap laws. The court said, and I quote, "The First Amendment right to gather news is not restricted to members of the press, but extends to private citizens as well. Furthermore, the right to film government officials, including law enforcement officers, in the discharge of their duties in a public space is a basic, vital, and well-established liberty safeguarded by the First Amendment." Since Glick, multiple circuit courts have affirmed this right. The Third Circuit, the Fifth Circuit, the Seventh Circuit, the Ninth Circuit, the 11th Circuit. The Supreme Court has not explicitly ruled on this issue, but every federal appellate court that has addressed it has sided with the right to record. So when an officer tells you that you cannot record them, they are violating clearly established constitutional law. That's not an exaggeration. That's the legal standard. Right number 1, you can record from a safe distance. Now, having the right to record doesn't mean you can do it from anywhere under any circumstances. The key limitation is that you cannot interfere with police activity. Interference is the magic word officers use to justify arresting people who record them. But interference has a legal definition. It doesn't mean the officer feels uncomfortable. It doesn't mean the officer doesn't like being recorded. Interference means you are physically obstructing the officer's ability to do their job, or you are creating a safety risk. So what is a safe distance? Courts have generally said that if you're far enough away that the officer can perform their duties without having to navigate around you, without you being in their workspace, and without you creating a distraction that could endanger them, you're not interfering. Practically speaking, this usually means 10 to 15 feet minimum. Some departments have policies allowing even closer proximity, but here's the important part. If an officer orders you to step back and gives you a specific distance, and that distance is reasonable, you need to comply. You can continue recording from the new position, but you cannot refuse the lawful order. The case law is clear on this. In Sharp v. Winterville Police Department, the Fourth Circuit said officers can require bystanders to move to a reasonable distance to ensure officer safety and prevent interference, but they cannot prohibit recording altogether. So the game is this. You have the right to record. They have the right to manage the scene for safety. As long as you maintain a reasonable distance and you're not physically interfering, you can keep recording. Right number 2, audio recording is included. This is where things get tricky, and it's where officers often mislead people. Some states have what are called two-party consent, wiretapping laws. These laws generally require that all parties to a private conversation consent to being recorded. Officers will sometimes claim that recording their audio violates these wiretap laws. This is almost always wrong when applied to on-duty police in public. Here's why. Wiretap laws protect private conversations. When a police officer is performing their official duties in a public space, they have no reasonable expectation of privacy. Courts have repeatedly held that on-duty police interactions in public are not private conversations. The Illinois Supreme Court, in People v. Malongo, struck down that states attempt to use its eavesdropping law against people recording police. The Massachusetts Supreme Court in Commonwealth v. Hyde ruled the same way. Even in two-party consent states like California, Florida, and Pennsylvania, courts have held that recording on-duty police in public does not violate wiretap statutes. Now, there are edge cases. If you're recording a police officer having a private conversation with someone inside a home, or in a location where there's a reasonable expectation of privacy, that might be different. But on the street, during a traffic stop, at a protest, during an arrest, you can record audio. If an officer tells you that you're violating wiretap laws, they're either misinformed or they're lying to intimidate you. You can respectfully say, "Officer, I'm aware that on-duty police in public have no expectation of privacy. I have a First Amendment right to record this interaction." Right number 3, you cannot be arrested for recording alone. Let me be very clear about this. In jurisdictions where the right to record has been clearly established by federal courts, an officer who arrests you solely for recording is violating your constitutional rights. That arrest is unlawful. It can form the basis of a civil rights lawsuit under Section 1983. Officers can be held personally liable. Departments can be held liable. This is serious. But here's the reality. That doesn't mean you won't be arrested. Officers still arrest people for recording all the time. They'll use pretextual charges: obstruction, disorderly conduct, interference, failure to obey a lawful order, trespassing, or even assault if you make any physical movement they claim was threatening. These charges are often dropped later, but by that point, you've been arrested, booked, maybe spent a night in jail, and you're out bail money and attorney fees. So while you have the right to record, and while an arrest solely for recording is unconstitutional, you need to understand that asserting this right carries risk in the moment. The fight happens later, in court, with an attorney. On the street, your goal is to exercise your right while minimizing the pretextual justifications they can use to arrest you anyway. The 3 magic words: "I'm not interfering." All right, here's the playbook. When an officer confronts you about recording, you need a verbal script that is clear, calm, and legally sound. The 3 words that matter most are, "I'm not interfering," but let's build out the full script because context matters. Step 1, acknowledge the officer calmly. When the officer approaches and says, "Stop recording," or "Put that phone away," your response should be, "Officer, I'm respectfully exercising my First Amendment right to record this interaction." Tone matters here. You are not arguing. You are not being hostile. You are stating a fact, respectfully. Step 2, clarify your position. If the officer insists or threatens arrest, you respond, "I'm standing at a safe distance. I am not interfering with your duties." Notice what you're doing here. You're addressing the only legal justification they have to stop you. You're creating a record, preferably on your own recording, that you are compliant, you are non-threatening, and you are aware of your rights. Step 3, comply with lawful orders to move. If the officer orders you to step back to a specific distance, you comply. As you move, you say, "I'm complying with your order, but I am continuing to record." You do not turn off your camera. You do not put your phone away. You move to the new location and keep recording. If they order you even farther back, you comply again. You make it clear on the recording that you are following every lawful order. Step 4, do not physically resist. If the officer moves to arrest you, you do not resist. You say clearly, "I am not resisting. I do not consent to this arrest. I was exercising my First Amendment right at a safe distance." Then you go limp, you comply with handcuffing, and you shut your mouth except to repeatedly invoke your Fifth Amendment right to remain silent. Everything else happens in court. What you cannot do, the boundary lines. Now let's talk about what crosses the line, because understanding your rights also means understanding their limits. You cannot touch the officer or their equipment. If you physically touch an officer, their vehicle, or their equipment, you can be arrested for interference or assault. Even reaching toward them, even accidentally bumping them, can be used as justification. Keep your hands visible. Keep your hands to yourself. You cannot refuse lawful orders. If an officer gives you a specific, reasonable order to move to a certain location, you must comply. Step back 15 feet is lawful. Stop recording is not. The difference matters. Refusing a lawful order to move can get you arrested for obstruction or failure to comply. But you can move and continue recording. You cannot trespass. If you're on private property and the owner or person in control of that property tells you to leave, you have to leave. Your First Amendment right to record doesn't override property rights. If police are on private property conducting an investigation and the property owner tells you to leave, you must go. You can record from a public space adjacent to the property, like the sidewalk, but you cannot remain on private property without permission. You cannot incite or provoke. If you're yelling, cursing, trying to distract the officer, or otherwise creating a disturbance beyond just recording, that can be disorderly conduct. Silent recording is protected speech. Screaming, "You're a pig," while recording is still speech, but it's speech that can be regulated as a public disturbance depending on the circumstances. Your safest play is to record silently or with minimal, respectful verbal interaction. Special situations. When recording gets complicated, recording in your own home. If police are in your home with a warrant, you generally have the right to record them executing that warrant. Some courts have even said this is a Fourth Amendment right to monitor what agents of the government are doing inside your private property. However, if officers order you to move to a certain room or location for safety reasons during the search, you must comply. Record from wherever they allow you to be. Recording as a passenger in a vehicle. This is a gray area. Some courts have said passengers have a right to record traffic stops. However, if the officer orders you to put your hands in a visible location for safety and holding your phone prevents that, you may have to choose between recording and complying with the safety order. If you're not the driver, you have more freedom to record, but you still can't interfere with the officer's investigation of the driver. Recording. During your own detention. If you are the person being detained or arrested, you still have the right to record, but it's practically very difficult. If the officer orders you to put your hands behind your back for handcuffing, you can't refuse that order to keep holding your phone. Your best bet is to have a bystander record or to start a live stream before the interaction escalates so the footage is preserved even if your phone is taken. The reality check. Is it worth it? I know some of you are thinking, Attorney Atlas, this sounds great, but in the real world, won't this just make things worse? And I hear you. There is a real tension between asserting your rights and avoiding escalation. Let me be honest with you. Recording police can make some officers angry. Some officers view it as a sign of disrespect or distrust. And angry officers can make your day very difficult, even if they don't have legal justification. But here's the counterpoint. The only thing that has ever held police accountable in modern America is video evidence. The Rodney King beating, Eric Garner, George Floyd, countless other cases where police misconduct was exposed only because someone recorded it. Without that video, those officers would have written their reports, and their version of events would have been treated as gospel. Video changes that dynamic. Video is the great equalizer. So yes, recording carries risk in the moment, but not recording carries risk too. The risk that if something goes wrong, it's your word against a police report. And historically, courts believe the report. Video evidence has exonerated countless people who would otherwise be in prison. It has exposed corruption, brutality, and misconduct that would have stayed hidden. That's why police unions fight so hard against body camera mandates. They know accountability changes behavior. My advice? If you feel safe doing so, record. If the situation is escalating and you genuinely fear for your safety, use your judgment. But know that you have the right, and exercising that right is not a crime. A critical warning about phone seizure. One last thing. If you are recording and you are arrested, officers may seize your phone as evidence. Legally, they need a warrant to search the contents of your phone, thanks to the Supreme Court case, Riley v. California. But they can seize the physical phone. This is why live streaming is so valuable. Apps like Facebook Live, Instagram Live, or ACLU's Mobile Justice app automatically upload footage to the cloud as you record. Even if they take your phone, the video is already preserved online. Before any interaction with police, make sure your phone is password protected, not just fingerprint or Face ID. Biometrics can be compelled. Passwords generally cannot, under the Fifth Amendment, enable auto-upload or live stream features if you have them. These small steps can mean the difference between preserved evidence and lost footage. Final thoughts. The right to record police is not about being anti-police. It's about accountability. It's about ensuring that the immense power we grant to law enforcement is exercised lawfully and transparently. Good officers should welcome recording. It protects them from false accusations just as it protects citizens from misconduct. If an officer is doing their job correctly, a recording only helps them. The 3 magic words are, "I'm not interfering," but the full script is longer. "Officer, I'm respectfully exercising my First Amendment right. I'm standing at a safe distance. I am not interfering." If you can say that calmly, clearly, and on camera, You've done everything right. After that, it's on the officer to either respect your rights or violate them. And if they violate them, you have the evidence and the legal foundation to hold them accountable. If you found this video helpful, please share it. This is information every citizen needs. Comment below if you've ever been told you can't record police. I want to hear your stories. And if you're binge watching these videos, check out my breakdown of the Fifth Amendment and when you actually have to show ID to police. Knowledge is power, and your rights only protect you if you know they exist. This content is for educational purposes only and does not constitute legal advice. Laws vary by jurisdiction, and some states have specific statutes regarding recording that may differ from federal constitutional standards. Always consult a licensed attorney for advice specific to your situation. Recording police is a constitutional right, but it must be exercised responsibly and lawfully.